Edward Balderas for the Office of Attorney General. Just to give you a little bit of history of this case, Your Honor, originally this case emerged as a default order that was done back on January 10th, 2025. Ms. Gonzalez was here, Mr. Rodriguez was not here. Um, After that order was entered, there was a motion for new trial filed by Mr. Rodriguez through his attorney, Ms. Meyer, and that new trial was granted. And a DNA testing order for genetic testing was done after that new trial was granted. We do have the DNA results from that order, and I can attach them to any order that we do here today. But they do indicate that Mr. Juan Rodriguez Jr. is the father of Carter Gonzalez by percentage of 99.999% repeating. And so we do have those available to us. I've briefly confirmed with both parties. From talking to both of them, I do think that there's going to be some contested issues, but I think there also may be some agreed issues that we may be able to put in an order today, Your Honor. And so I believe for the contested issues, since Mr. Rodriguez is not here, the state would object to going into the contested issues today because I do believe his testimony will be necessary on what they disagree about. But perhaps there is something that they can agree to today to at least get some temporary orders in place before moving forward to a final order.
Okay, and Ms. Meyer, to the extent that you agree or disagree with Mr. Balderas or have something new and different to say, your opening statement, ma'am.
First of all, yes, I agree with Mr. Balderas. My opening statement would be that my client, what he has told me, obviously I can't testify, what he has told me was he did not know the child was his. That's one of the reasons he asked for the test. Now that the test is verified and confirmed he is the father, he's more than willing to, take his responsibility. He would like to have visitation with the child. Well, the child's 15, so he would like to get to know him. I have his income here. He's ready to take care of paying the child support, and he has medical insurance available at his work. He's more than willing to add him to his medical insurance. I think that's about it. The only thing we do object to is any past child support, and that's where the testimony, I believe, is going to come in.
Okay, what about any kind of possession and access at this time, or just to punt till he shows up, or do y'all have anything in mind?
He would like to get to know the boy at first because, he's 15 and they have had no contact. So maybe some Zoom or some kind of weekly meeting.
From the first words, the courtroom feels tense and serious.
Things for them to get to know one another, FaceTime or something, and then gradually go into some visitation.
Okay, so if you can work something out here, I guess on the record in Ms. Gonzalez, you'd be okay with it, but if you can't, that's an issue we'd have to punt.
I'm okay with visitation.
Okay, Ms. Gonzalez, we're gonna get to you in a moment. My question was for Ms. Meyer first.
Sorry.
Yes, I think that if we could maybe establish some kind of communication between the two where they could have, at least phone conversations and FaceTime, something of that nature, without any interference, that would probably be a great starting point until my client can be here, testify, and tell you what, more in detail what he wants.
Okay, well, let's go forward, and then Ms. Gonzalez, I'm gonna hear exactly what you're asking for right now, but it looks like it's gonna be temporary orders with another court date coming, so we can deal with that contested issue of back pay on another day. So, Mr. Balderas, it's your pleading. You want to go forward with testimony from Ms. Gonzalez?
Yes, Your Honor. State will call Ms. Maxine Gonzalez. Ms. Gonzalez, going back a little bit in time here to that original order that a new trial was granted on. In that order, you were appointed as the two of you were appointed as joint managing conservators, with you as the primary managing conservator for Carter. There was some child support ordered. There was some medical support ordered. and there was some visitation. So I just kind of want to go through those three things and see where you're at with regard to them. Do you believe that you should remain the primary managing conservator for Carter going forward?
Yes, sir.
Okay. And is it true that Mr. Rodriguez hasn't had any contact with Carter since he was born?
Correct. No, sir.
Okay. Do you believe that Mr. Rodriguez would be any harm to Carter physically or emotionally, or do you just not know?
I feel like him being present is he's already emotionally hurt, but I don't think he can be any more hurt.
Okay. Okay. Are you, but I guess let me
I don't
ask
think
you-
he will harm my child. No.
Okay. You're not worried about any like violence from Mr. Rodriguez or anything like that?
No, sir.
Okay. Does he know where you live? Do you know? Mr. Rodriguez know where you live?
Yes, sir. He does know the address.
Okay. So if that address was in a court order, so he would have access to it, would that be okay with you?
Correct. Yeah. Same
Okay.
address as in previous court orders.
Okay. In that order, and just from, hearing Ms. Meyer's statement and what you've said as well, Ms. Gonzalez, I look back at that original order that was that we're talking about here, and there was
Her reasoning struggles to hold up under direct scrutiny.
a deviation from the standard visitation schedule. There was visits to begin at 9 a.m. and end at 2 p.m. on the first, third, and fifth Saturday of each month, to have the exchange be at the Raising Cane's Chicken Fingers restaurant over in New Braunfels. Do you recall that being in the order?
Yes, sir. I do.
Okay. And when that was created, was that intent? Did you intend that to be, or was the intent to be that they could get to know each other, to get introduced to each other, to because Carter likes that restaurant and maybe they could share a meal together perhaps and move on from there whatever they chose to do?
Correct. Yes, sir. Yeah, that was just for them to establish a relationship, to get to know each other. And a set time, since Carter is 16 years old and he would love to have a job of himself to establish him into the workforce. But that at least gave him a set time of when he could tell his employer that he's unavailable.
Okay. And was your intent with that order to be the one that drops Carter off and picks Carter up at that same location?
Correct. Yes, sir.
Okay. And so, do you think that would be a good idea to for at least for the temporary basis, for them to be able to see each other according to those times and that time and place, like you originally intended back in the first order?
Correct. Yes, sir. And I can even agree to, as she's saying, Zoom or FaceTimes without any interruption,
Okay.
as well.
Do you have a specific time in mind or a day where they could talk to each other on FaceTime, perhaps?
It would have to be a weekend, since
Okay.
he is in school full-time Monday through Friday.
Okay.
I would say Saturday mornings are great, or Sundays we do attend church, so Sunday afternoon would be great as well.
Okay. So Saturday morning,
I'm
or
pretty open to them establishing a relationship if
okay. Does Carter have his own phone?
he does. Yes, sir.
Would you be willing to give Carter's phone number to Mr. Rodriguez?
Yes, sir.
Okay. And I don't want you to say that phone number on live stream here.
Gotcha.
So maybe after the testimony, I'll find out what that number is from you and include it in an order.
Okay.
But okay. And so, and in fact, as part of that original order, there was also electronic communication that was ordered as well. There was no specific times or dates, but it was at any reasonable time and any reasonable duration that the two of y'all could agree on. But perhaps if we put something a little bit more specific, that might help the process. But okay. There was some child support that was ordered as well. And the child support amount that was ordered was $800 and $83 a month. And that was back then to begin in February of 2025. Are you in agreement to start that amount in child support starting next month here, December?
Here the father calmly exposes her choices, shifting the case.
September 1, 2025, with the understanding that the issue of retroactive child support and everything that's been before today still has to be addressed in the future.
Correct, yes, sir.
Okay. So does 883 sound appropriate to you?
Yes, sir.
Okay. There was some medical support that was ordered based on a government assistance health plan, and there was an amount for medical support ordered in the amount of $57 per month. Can you tell me, is Carter still on the government health plan?
Correct, yes, sir, he is.
Okay. Then the state's recommendation would be for that to remain the same as well, $57 per month, beginning September 1, 2025. Ms. Gonzalez, were you able to see the DNA testing results that I had mentioned earlier to the judge?
No, sir.
Okay. Well, I'll include that in the court order so you can see it. But now that we have those results and also you're here to testify, the state is asking the court to find that there is the parent-child relationship is established between Carter and Mr. Rodriguez. Are you in agreement to do that today, ma'am?
Yes, sir.
Okay. And so I think that's everything I wanted to ask you about for now, at least with regard to what I think you're in agreement to do today, at least. But I guess to give the court an idea of what still needs to be addressed, you're asking for retroactive child support going back to the time Carter was born. Is that right? Or
I was
shortly
asking
thereafter?
for the original date of my attorney general was, I want to say it was back in 2015, but those cases were closed because he could never be served. Because he lived in California, where they say he would, he wasn't stating that he was served. So
Okay.
there's been, I think, 2 separate cases that have been closed by the attorney general because the other party had never been served.
Okay. All right. Okay. Well, I don't want to delve too much into it, but that's going to be an issue for a future hearing.
Yes, sir.
Okay. All right. Well, thank you very much, Ms. Gonzalez. I'll pass the witness.
Before you go forward, Ms. Meyer, Mr. Valderas, Ms. Lejas is not here, but there's a CP from another case that came back. She's in the waiting room. Should I let her in and reassign her, or you let her in? Or I was already told there was a reset on that case. I don't know if she has further questions, or we'll just leave her in the waiting room and finish the hearing.
Yeah, I don't know anything about her, Your Honor.
Okay, I don't know who was talking to her before that. Okay, well then, she'll just have to wait for a minute. Let's move on. Ms. Meyer, any examination of Ms. Gonzalez?
No, Your Honor.
Just an abundance of caution, is there anything that you haven't been asked that you think is necessary to say right now on your own behalf? Ms. Gonzalez, as you're not here with a lawyer, is there anything else you want for the record for a temporary order today?
No, ma'am.
Not really. Okay, then I don't have any questions either. So there's no other witnesses to call, Mr. Valderas
No, Your Honor.
or Ms. Meyer?
No, ma'am.
Well, I guess I know what the state's asking because and what Ms. Gonzalez is asking for, but I guess it's more pertinent to me, for me to hear from you first, Ms. Meyer, on what parts you agree or don't agree with, and then to figure out a court date for me as well with our calendar for the rest of the year, so.
Yes, Your Honor.
Do you don't mind if I let Ms. Meyer go first, Mr. Valderas? Normally you would go.
No, of course not. Please.
Thank you.
Thank you. Yes, we do agree to joint managing conservatorship with mother being primary. We do agree to the child support, except I went through the numbers. He makes $1,023 a week on the average. That's his net. I put together some
The judge turns up the heat, pressing her with tough questions.
checks. I don't know if that's 883 or not, but it's $1,023 a week.
Did you figure out the monthly amount, and does it correspond to the state's finding in the default order from before?
I think it might be a hair less. I think it's closer to 800 a month. It's just, but I rely on Mr. Valderas to tell us on that. What I did was I took his paychecks and I included about 10 hours of overtime because his overtime goes up and down a little. So I included the average, which is 1,023 a week net. As far as the, let's see, that was on child support. Medical support, he does have private insurance available through his employer, but it might be easier for everyone if we leave it at the $57 pay.
At
And
least for a temporary order, yeah,
yes,
yeah, okay.
as far as possession access, I think we agree, the 9 to 2. I will have to ask him Saturday or Sunday. Maybe they can agree to which, but I think Saturday is probably okay. I don't know if he ever works on Saturday. If it can't be Saturday 9 to 2, I'd say maybe Sunday after church till 6, or maybe 1 to 6 or 1 to 7, something like that. The exchange location is fine. I think, and then of course, yes, it would be nice if he could have Carter's phone number so he could communicate with him at will, and Carter especially could communicate with my client at will. Other than that, the only things we still have on reserve would be, well, the only thing on reserve really is the retro.
Okay, you wouldn't object to the electronic communication as the previous order?
Not at all.
established? Yeah,
Fine.
add that too. And even if it's on a Sunday, or does it matter? We leave it at reasonable times and durations, Ms. Gonzalez, so y'all can figure it out with the child and with his work schedule and with whatever else comes up.
Correct. Yes, ma'am. I'm open to different times and
Okay, well, that may be better than setting it in stone and then it doesn't work out, but okay, so the last thing would be a reset date, but also I guess a kind of a pending issue is child support. You didn't get to review the pay stubs before you got into the courtroom, Mr. Valderas?
No, I have not, Your Honor, but based on what Ms. Meyer has said with regard to what he's making net per week, that's very close to our number that we had in the court order. Ms. Meyer's number, I think, comes out to 4,433 net a month, and we had 4,415.33 net a month.
So we could just stick with what you have, I guess. It's fine. I'm not gonna put it.
I think for a temporary basis, I think
That
the
would-
883 looks pretty close to, and we can, I guess, be more specific or redo the calculation at final hearing if necessary.
Okay. Mom already agreed to that. I guess you're agreeing to that now, Ms. Meyer, just so I'm real clear on that.
Yes.
Okay. Yeah, and well, one last question. He doesn't have any other children that you're aware of, Ms. Meyer?
No.
Minor children, and you don't know anything about him, Ms. Gonzalez, so if you had other
No.
children, Ms.
No,
Meyer.
ma'am.
Okay, so with no credit for other children. Then I think we have an agreement for temporary orders with pending court date. How far away did y'all want to come? I think this is not a young child, so I'm not worried about seeing what happens on visitation necessarily, but a month or 2 or 3. I'd rather not go into December if at all possible. Those are limited dockets with usually a lot of
Tension peaks as excuses crumble and frustration fills the room.
It won't fill up.
Okay, you don't have a problem with that Friday date, Ms. Gonzalez, October 24th?
No, ma'am. I'm available.
Okay, and do you want to leave it at 10:30 or go to 8:30 in the morning to try to get out quicker?
I can do 8:30.
10:30, 8:30. Let me flip a coin. No, I won't.
I can do 10:30. That's fine.
10:30.
Yes,
That might work with a lawyer's schedule. If she has to be somewhere else, she can get away and get here on Zoom by 10:30. So October 24th at 10:30. You heard everything the lawyers have said. Ms. Gonzalez, do you agree? Now having heard Ms. Meyer, there's not anything else you need to add or that you didn't agree with?
No, ma'am.
So we'll just leave, I think, though I didn't repeat the visitation, but it's the same as the previous order, and right?
For the most part, Your Honor, I think we can add in Sundays from afternoons after church, 1 to 6 or 1 to 7, perhaps, as days to do the visits.
You want to
Either
do
or.
first, third, and fifth Saturday or Sunday, and then let it go and see what happens.
I think so, Your Honor. I think that would be fine.
So it's not like we're setting up both days. It's just in case your child's working or Mr. Rodriguez is working on Saturday, then y'all go to on Sunday, but it would not be 9 to 2. I assume you have a routine with church in the morning or whatever. Ms. Gonzalez, what would Sunday hours be different than 9 a.m. to 2 for a visit?
Correct, yes. We do go to church at 9 a.m., so I do agree to the hours to like 1 to 9 or 1 to 8. I try to make
Yeah.
sure he's at home by 9 o'clock so that he's in bed at a decent hour for school.
You gave him 5 hours on Saturday. You want to do more than that on Sunday, or just keep some kind of,
That the 5 hours is fine, yeah, on Sunday as well.
what do we say? 2
1
to
to
7
6.
or 1 to 6? That would be better. 1 to
Yes, ma'am.
1 to 6. And you would not be opposed to that, Ms. Meyer?
No, ma'am, that sounds great.
9 a.m. to 2 p.m. first, third, and fifth Saturdays, or 1 to 6 p.m. on first, third, and fifth Sundays, or.
And we'll need to maybe put in there that Mr. Rodriguez would probably need to give them some advance notice, maybe 3 days heads up on both parties.
Correct, yes,
Um,
ma'am. If I could ask that, yeah, just a heads up.
Do you want 3 days or 2 days, 48 hours or 72 hours, Ms. Gonzalez?
48 hours is perfect.
That should be enough for everybody's purposes for the limited visits, sure. 48 hours advance notice, and then you want him to text you on your cell phone?
Correct, yes, ma'am.
Advance notice text to mom, okay. I think we got the details down on everything. Is that correct, Mr. Valdes?
Yes, Your Honor. I think so. But just to summarize, temporary order with joint managing conservatorship of Ms. Gonzalez primary. Current child support of $883 per month beginning September 1. Current medical support of $57 a month beginning September 1. Visits on Saturday or Saturday from 9 to 2 or Sunday from 1 to 6. Exchange point being the Raising Cane's Chicken in New Braunfels with a specific address. DP's phone number to be included in the order, and the finding of paternity with the DNA testing results as well. And a reset to 10/24/2025 at 10:30.
Okay, and DP means the dependents is the child's phone number you have to provide to Mr. Rodriguez, Ms. Gonzalez, okay?
Okay, yes, ma'am.
I think that covers it. Anything, oh, electronic communication, don't forget that.
Yes, Your Honor, plus electronic communication.
Yeah, I guess you're gonna reiterate the same findings from the other order to support the 883, and that could change it a little bit. We could deal with that at the final stage too. Okay, then I'll approve the agreement of the parties on the record here and render the order. So now it becomes my order. However, the state will draft it, send it to you all by email. Look for anything coming from the Texas Office of the Attorney General. That's this proposed order. Ms. Meyer knows what she's doing, but Ms. Gonzalez, you need to open it, consider it priority homework, and review it electronically, sign it as quick as you can. I don't hope you don't see any errors, but if you see anything that doesn't make sense or you have questions about, call the state and figure it out. You can't call me, or you call, because you don't have a lawyer. If you have questions, you want to call Ms. Meyer. I think you can talk to her, but chances are you don't need to talk to her. Do you have any questions all about what we're doing here today and the follow-up on that, Ms. Gonzalez?
No, ma'am, no questions.
You are on legal notice to come back to court on October 24th at 10:30 this year, and it is by Zoom. It'll have the same Zoom ID. It'll all be in the order as well. Failure to return to court, since civil matter, nobody gets arrested, but if you don't come back, you could be defaulted. So that would not be in your interest to go forward without you and without your testimony that day. You understand that too. We need you back.
Yes, ma'am, I understand.
And the consequence is a default. Okay, then unless there's anything from the lawyers, Mr. Valdez, we're done.
Yes, Your Honor. I should have that order drafted. I'm leaving for the afternoon, so I would imagine it would be there on Monday morning, maybe Monday early afternoon.
And remind me, did you need something from her off record, so I shouldn't release her yet?
Just the phone number for Carter.
Okay, then don't leave yet, Ms. Gonzalez. However, and Ms. Meyer, you have nothing else for the record, just an abundance of caution here.
Yes, ma'am, we're good. I'm
Good. Then thank you, folks. That concludes this, and if I said it or didn't say it already, it is my order. I render the order now. I will conclude this hearing. I'll stop the recordings.
Finally, the verdict lands, and the outcome is crystal clear.